In Unit 2, we're going to cover ethics and integrity, dealer license suspension hearings, established place of business requirements, zoning compliance, fraudulent dealer applications, dealer insurance records, and odometer disclosure. So let's get started right now with dealer ethics. Dealer ethics and integrity. It is obvious to you by now that it is imperative that we operate our dealership with complete integrity and the highest ethical standards at all times. We need to follow every state and federal guideline on every transaction, period. If you don't operate strictly under all state and federal regulations, your dealer's license can result in suspension or revocation. And once you've had a dealer's license suspended or revoked, it's time-consuming and maybe very costly, including legal fees and other fees if applicable, in order to obtain another dealer's license. So, being completely honest with every one of your customers is a win-win situation. You're going to build your reputation as you sell your vehicles. And, you definitely want to make sure that you've always got an ethical reputation. A good, positive selling experience with the customer will lead to more sales to the customer's friends, their coworkers, and their family. A bad negative selling experience will result in customers leaving negative reviews of your dealership all over the internet. It's very easy for your customer to leave negative reviews and comments on Google and Facebook and Twitter and other websites. So when future customers see the reviews, they're not going to purchase vehicles from you. And a bad reputation is nearly impossible to discard. Customers want a dealer they can trust. To maintain your honest reputation, you must offer full disclosure on all vehicles before the sale. Always disclose every minor mechanical malfunction that you're aware of before the test drive. And by disclosing everything you know about a vehicle before the test drive, you are going to build an incredible reputation in your area. Unethical dealers can never discard a dishonest reputation. By operating your dealership with complete honesty and the highest ethical standards at all times, you will gain an honest reputation that will lead you to many, many more sales than that of a dishonest dealer. Being completely honest with your customers is a win-win situation. You're going to have the best reputation in your area, and you will have the highest profits and be in business for many, many years. A customer is going to trust a lot more of an investment with you, the honest, ethical dealer, than they do that dealer down the street that's just, lying to every single person that comes in the door. So also, operating your dealership with complete integrity and 100% compliance equals more profits because you never pay any fines by maintaining 100% compliance. If you're not maintaining compliance, you will have fines. And so I always recommend go the extra steps, take the additional steps to maintain 100% compliance. That way you will always maintain 100% profits. Complaints against Georgia dealers. The Georgia legislature has determined that used motor vehicle dealers operate a business that affects the health, safety, and welfare of the public. Therefore, the used car division of the State Board of Registration of Used Motor Vehicle Dealers and Used Motor Vehicle Parts Dealers makes it very easy for a customer to make a complaint against you. In fact, as you see here, the state has an entire page of information instructing consumers how to file complaints against licensed Georgia motor vehicle dealers. They can easily call a toll-free number to contact the Governor's Office of Consumer Protection, or they can easily download, complete, and submit the famous dealer complaint form that you see right here. The state also maintains a web page for your customers to log on, and they can easily make complaints online. So not only can they fill out the dealer complaint form, they can easily jump right onto the website and fill it out online. So the state, really makes it very, very easy for your customers to submit complaints against your dealership. And we want to avoid having our customers make complaints against us to the state. First, always make sure, like I said, maintain 100% compliance with your dealership by following every rule, law, and state guideline, and do your very best to make sure your customers are happy. If you have a customer that you sold a vehicle this morning, and now that customer is coming back in the dealership this afternoon through the front door, well, you don't want to go running out the back door. In fact, if you see a former customer coming into your dealership, I always recommend putting all your sales activity on hold and focus on the previous customer. We basically want to fly under the radar here. We do not want the state hearing your dealership's name over and over and over again because of all of your angry customers. If most of your customers are logging complaints against your dealership on a regular basis, then the state's going to realize that you are probably not conducting your business in compliance with state and federal laws. Making sure your customers are happy should always be one of your top priorities. We do not want our customers filling out this dealer complaint form for sure. But next, I want to cover suspension or denial of a used motor vehicle dealer's license. You know, when you're granted this dealer's license that you've had here in the state of Georgia, the state of Georgia is basically giving us an opportunity to enter a business field that can be quite lucrative. However, we must follow several sets of rules and guidelines. All Georgia used motor vehicle dealers must follow the laws that we discussed today, and the state has zero tolerance for any dealer that does not follow the rules. Any dealer that does not comply or follow the rules can have their dealer's license suspended or revoked. Reasons for suspension of a denial of a used motor vehicle dealer's license. You know, the department may refuse to issue a license and may cancel or suspend a license for conviction or violation of crimes involving violence, used motor vehicles, illegal drugs, tax evasion. That's a big one right there. Failure to pay taxes, any crime involving illegal use or carrying possession of a dangerous weapon or moral turpitude. And the department may refuse to grant or renew a license to any person if the person is a delinquent taxpayer and has not filed all state tax returns that the person is required to file. So, they will require us dealers to stay up on our taxes. So that is something we need to be aware of. Or if you ever submitted false information on a dealer license application or a renewal, you could be also convicted of a misdemeanor if you ever lie on a dealer license application or a renewal application. Also, if you did not complete your continuing education, this is mandatory. We've got to make sure that we always complete our continuing education in a timely manner. Otherwise, we will not be able to have our license renewed. Here's some other reasons for dealer license suspension: making any substantial misrepresentations on the vehicles we're selling. Forging documents is obviously a bad thing to do. We're never going to do that. Use of untruthful or improbable statements or flamboyant or extravagant claims concerning such licensees' excellence or abilities is actually a reason you can get your license suspended. Acting to obtain or holding a license on behalf of another person who was previously denied a license. I want to repeat that one there. Acting to obtain or holding a license on behalf of another person whose license was previously denied a license. So, I know cases where there might be a husband whose license was revoked and then he turns around and just has his wife get the license. That's against the law. We cannot ever hold a license on behalf of another person whose license was denied or suspended. If you sold a vehicle that was stolen, I'm going to show you how to look up vehicles here in a little bit to make sure that they are not reported nationwide as a stolen vehicle. Failed to pay penalty fees implemented by the board. Not maintaining proper records, which we're going to cover here in just a little bit to give you a reminder on your required records. Also, failure to obtain a certificate of title for a purchaser. That's one of our responsibilities, is making sure that our customers get their titles. License suspension hearings. When the state has reason to believe any dealer has violated any provision of the code, the department shall schedule a hearing to determine whether or not the dealer's license should be canceled, suspended, revoked, or continued. No license should be suspended or revoked without a hearing, and that's according to the Georgia Administrative Procedure Act. So it is a democratic process. If we ever have a license suspension or denial, it is a democratic way of doing things. So we do have a right to a hearing. So if you ever do have your license suspended or possibly your dealer license renewal application was denied, you can schedule a hearing and testify in front of the board. A license suspension hearing is something you certainly want to avoid. Maintaining 100% compliance will hopefully ensure that you never have license suspended or denied, because it can take time and money for the dealer to go through a license suspension hearing. But you heard me mention the board. The official name of the board is the State Board of Registration of Used Motor Vehicle Dealers and Used Motor Vehicle Parts Dealers. And the board is composed of two divisions: a used car division and a used parts division. The members of the used car division, which has oversight over most of us, has 3 independent used car dealers, 2 of the members from the public at large, and then a state revenue commissioner or a designated agent, and the representative of the automobile auction industry and the pawnbroker. So, it's a real diverse setup. It even has persons with absolutely no dealership experience to kind of get a good viewpoint from every person on the board. The division director shall be the secretary of the board and of the division. So the board has a very diverse makeup, and each board member is actually appointed by the governor. So it's pretty prestigious to land on the board, obviously. All members shall be residents of the state, and no more than 2 of the appointed members shall be from the same congressional district. So they have it written in state law, the diversity of the board, how it must be made up. But here I want to show you the minutes of some board meetings that shows complaint reports. So I definitely want you to be aware what happens when there is a complaint against your dealership. And I blacked out all the dealer numbers, but I want you to see all the complaint reports that took place at just one board meeting. This was just one boarding meeting. And as you can see here, one dealer was fined $250, but some penalties for non-compliance are much, much harsher. And here I want to show you a portion of the board minute that includes a cease and desist order where 2 dealers in Lawrenceville were ordered to actually close due to violations. So, the board meets every month in Macon normally, and you can always call in advance 478-207-2440. Once again, that is 478-207-2440 for the board schedule. And if you ever get a chance to go to a board meeting in Macon, I'm sure you're going to find it very educational. But if we go to a board meeting, we want to hopefully make sure that it's of our choice and not because we had a license suspension. That is one reason you hopefully will not be required to go to a board meeting. But if you want to go check out a board meeting, they're very informational, and I think you'll find it very educational as well. Next, I would like to cover the Georgia Fair Business Practices Act. Georgia's Fair Business Practices Act prohibits unfair and deceptive acts or practices in the marketplace. And the act applies to consumer transactions, including the sale of motor vehicles by licensed motor vehicle dealers. You certainly want to be aware of this law that will affect your day-to-day operations, and also be cognizant of the act will help you maintain your compliance. There are several components of the Georgia Fair Business Practices Act, such as passing off goods or services as those of another. So let's say, for example, you're selling a motorcycle that was made by Yamaha, and you tell the customer it's a Harley Davidson. Well, that would be a violation of the Fair Business Practices Act, claiming that goods come from a particular place when in fact they do not. You might be selling a trailer that was made in Mexico, but you tell the customer it was made right here in Georgia. That's a violation of the act as well. Representing that goods are new when they're actually used. So you can never tell a customer that a vehicle is new unless it is actually new, and you're basically selling it on an MSO, and that's usually what that's going to be a franchisor normally. Making false or misleading statements about another business or its products or services. You can never make false statements about another business. Say, for example, you tell a customer that Joe Bob Auto down the street is selling vehicles that are totally junk. Well, you're in violation of the act. We can't disparage the goods or services of a competitor or any other business. Advertising goods or services without the intent to sell them as advertised. You can't run an ad for one vehicle, only switch the customer to another vehicle. That would also be a violation of federal advertising law. And we're going to cover advertising law in just a little bit. Advertising goods or services without having enough merchandise on hand to meet expected demand, unless the advertisement states limited quantities, okay? Making false or misleading statements about sales prices. You can't tell the customer the price of this vehicle is today only when you've been running the same sales price for 2 weeks. That is never allowed, and that's another violation of the act. Always be sure you're complying with the Fair Business Practices Act. This is going to help you ensure that you do maintain your 100% compliance. Let's also cover our established place of business requirements. Just to kind of give you a reminder, I want to give you a quick overview of your established place of business requirements to ensure that you're always maintaining compliance on your building. An established place of business must be devoted exclusively to the business for which the dealer is licensed and any business incidental to the dealer's principal activity. Established place of business means a sales room or sales office in a building on an open lot of a retail used car dealership at which a permanent business displaying used motor vehicles takes place. The business location is where you're always going to store your books and your records and the files that are necessary to conduct your business. And we'll give a little records overview here in just a little bit as well. As a reminder, your business building must have a working telephone listed in the name of the licensee for use in conducting the business and cannot be a cell phone. So make sure you got that landline. Okay, we got to make sure that we always have that landline. A cell phone does not ever qualify as your official dealership phone. Okay. If you post a phone number on your sign, it must be your official phone number that's listed in the telephone directory service and the number listed on your dealer license application. So you want to make sure that is your official phone number if it is listed on your sign. Your building must have a permanent sign which shall be in compliance with board rules and local ordinances of the particular city or county in which your dealership is located. Your sign must also include the same as that is which is on the dealer's application and in any advertisement used by your dealership. And so always make sure, we've got to always make sure that our dealership name is on the application that matches the dealership sign. And that's also going to be the official name. This basically, if you've registered with the Secretary of State or you've got your dealer surety bond, you always have to operate under one name. And that sign must be readable from the nearest roadway. So always make sure the letters on your sign are large enough to be read from the nearest roadway. Also, always remember your display lot must be the same address as your building, unless you're a broker. And then obviously you're not required to have a display lot. But a retail dealer must have your lot as the same address as your building. Remember also the dealer license must be displayed. A dealer must display their business license issued by the department in a conspicuous place at the dealer's established place of business at all times. I know you've worked hard not only to gain your initial license, but to maintain compliance so you can always renew your license. And I'm sure you're proud of that dealer license. So make sure you never store it in some desk drawer or a file cabinet or a vault. Be sure to display your dealer's license prominently. This is a state law. All dealer's licenses must be displayed prominently. Be sure you also never alter any type of title evidence or anything like that because you can be charged with a felony. And we'll talk about that a little bit later on as well. Let's go ahead and talk about dealer insurance. I want to give you a reminder on this and a little bit of an overview. The state of Georgia requires every motor vehicle driven on any roadway to be insured, including your demos and all service vehicles that are owned by your dealership. It is illegal to drive any motor vehicle in Georgia without proof of insurance or financial responsibility. You're probably aware of that, but I want to repeat that. It's illegal to drive any motor vehicle in Georgia without proof of insurance or financial responsibility. It's also illegal for any motor vehicle owner, such as the dealer, to allow anyone else to drive your owner's vehicles, such as your demos, without insurance. So not only is it illegal to drive vehicles without insurance, it's illegal for a dealer to allow customers to drive a demo that does not have insurance. So I want to cover your limit amounts here, just to give you a quick reminder. And you can always call your insurance agent for updates on this. We've got to make sure that we do have the bare bones minimum under state law. You're going to have that minimum of $50,000, $100,000, $25,000, or a single limit of $125,000. Garage liability coverage must be shown. Automobile liability is never accepted. I want to repeat that. You got to have garage liability. You can't just have an automobile liability policy like a regular vehicle has. That's never acceptable. The location on the certificate must once again be the exact name and address that is shown on your dealer's license application or renewal. The certificate holder, as a reminder, must be the State Board of Used Motor Vehicle Dealers with the address of 237 Coliseum Drive, Macon, Georgia, 31211. Before you purchase any inventory, obviously you've got to have your insurance in effect. So, dealer insurance is really that special type of business insurance, and it's quite unique in nature that it is always going to cover us when our customers are out test driving vehicles, and it's going to cover us, when our employees are driving a vehicle, say, for example, back and forth from an auction. But another thing about your insurance, it's going to cover you if someone is injured on your lot. So, if somebody breaks their leg on your lot, we're going to be covered for that. And, if you need an update on your policy, always remember many insurance agents do not even quote or sell dealer insurance. And, you might have your regular insurance agent, you call them just to give an update, and maybe they don't really handle dealer insurance. And, if that's the case, or if it is time to maybe requote your policy, you need to contact an insurance agency that carries commercial insurance and specializes in specific commercial coverages. Be sure they can explain the best type of coverage that would be best for your dealership. And always remember, your dealer insurance pricing normally depends on the location of your dealership, your experience, the number of dealer plates that you possess, and also it can be, quite expensive, but, once you become established without claims, and there's a 3-year plateau in the industry, normally you're going to find out that no claims should lead to lower insurance costs later on, once you've got 3+ years of experience. And, this might be a good time to be requoting costs. So you definitely want to know the different types of dealer insurance that we're going to talk about right here, okay? First, let's start with dealer liability, or sometimes we call it garage liability. And your insurance agent might even call it garage coverage, even if you do not have a garage. It's your dealership. Dealer liability is just like liability on your own vehicle. If your customer wrecks your demo into another vehicle, it's going to cover the other vehicle. It will never cover your demo because it is only liability. Dealer liability will never cover the dealer's property. So realize that you do have an element of risk because your insurance will not cover any property losses. And, I have spoken to more than one dealer that's had significant investment in their inventory only to see it wiped out due to a storm or a tornado. So, don't ever let this business be the reason you could go into financial ruin, because if you do not have enough insurance on your inventory, that's definitely playing with fire, I guess is what we would say. Next, let's talk about dealer's open lot. You might think of dealer's open lot as full coverage insurance on your inventory, although we do not refer to it as full coverage, obviously. We refer to it as dealer's open lot coverage. Dealer's open lot does not cover a specific amount of vehicles on your lot. It covers a dollar amount. So let's just say you have $50,000 worth of inventory on your lot. Then you need $50,000 worth of open lot coverage. The state may have tornadoes. We've had tornadoes, floods, hurricane could hit parts of a dealership, down on the southeast part of the state. Even an earthquake could destroy your inventory. So, just keep that in mind. I recently saw pictures of a dealership that was struck by a tornado and lost 700 vehicles in about 3 minutes. So, if you might remember a couple of years ago when Hurricane Harvey hit the Gulf Coast of Texas, it flooded Houston, and over 1 million vehicles in Houston sat in water for about 2 days. And if you can ever imagine throwing a computer in a bathtub for 2 days and expect it to work afterwards, well, there's really no difference with the vehicle. So we need to be concerned about theft as well. And, I've read articles covering dealers that have had their entire inventory stolen overnight. So, if you ever showed up to your dealership in the morning only to find that your entire inventory was gone, you would not be the first dealer that's actually happened to. So, as I said, I have seen dealers go into financial ruin because they did not have enough coverage on their inventory. So if you do know a dealer that's lost inventory, always definitely keep them in mind. We do not want to be that person. Open lot is going to cover your inventory, usually damaged by wind, natural disaster, and sometimes hail, although sometimes hail will require an additional rider. So, and also it should cover you in cases of theft. So let's make sure that we never, ever go into financial ruin. Let's cover some garage keepers. Give you an overview of garage keepers. Garage keepers covers vehicles that are owned by the customer that is leaving the vehicle with you for repair. So if you repair vehicles for customers, garage keepers insurance would cover you if something happened to the customer's vehicle while it's in your possession. So most garage keepers coverage will also cover tools that are used to repair your customers. So basically, always remember, if you keep a garage for repairs, you need garage keepers insurance. Now we're going to cover a very important type of insurance, which we refer to as errors and omissions. So many dealers are not aware of this coverage. So this is coverage you certainly might want to talk with your insurance agent about. Errors and omissions covers a dealer that may have failed to comply with the Federal Truth in Lending Act, or maybe the failure to display your FTC buyer's guides, which we're going to talk about later on, or maybe you made an error in paperwork that was submitted to the state, or failed to maybe disclose prior damage that you were totally unaware of, or maybe you failed to perform a title search. So errors and omissions basically covers paperwork errors and omissions for a dealer. Something else we need to be aware of is a type of policy called an employment practices liability. Employment practices liability provides coverage against sexual harassment lawsuits, wrongful termination of an employee, wage payment disputes, deprivation of career opportunity, discrimination, etc. There are many anti-business attorneys that love to file lawsuits against dealers. So be aware that employment practices liability is something you should definitely consider. So do consider talking to your insurance agent about employment practices liability if this is a type of coverage that you don't already have. Another type of insurance I want to talk to you about is called workers' compensation. And workers' compensation provides coverage in case of workplace injury to an employee. So, today modern workers' comp laws provide specific benefits to workers who suffer workplace injury or illnesses. And, benefits to workers' compensation could include medical expenses, death benefits, lost wages. I want you to be aware the state of Georgia does require if you have 3 or more employees, you must have workers' compensation. And I think there's a lot of dealers that are probably not aware of this law. I want to repeat it. Georgia law requires if a business, including a dealership, has 3 or more employees, you are required under law to have a workers' compensation policy. Failure to carry workers' compensation insurance or otherwise meet a state's regulations in this regard can leave a dealership exposed not only to paying these benefits out of their pocket, but also paying significant penalties that will be levied by the state. State penalties for non-coverage are quite severe, so you should definitely talk to your insurance agent about what type of workers' compensation would be best for your dealership. Remember, if we have 3 or more employees, state law requires that we do have workers' compensation. False pretense. A lot of dealers confuse false pretense insurance with errors and omissions insurance, and the two types of coverages are quite different in nature. False pretense insurance covers a dealer, say for example, that purchases a vehicle from someone that did not have the legal selling rights, and also covers when a person purchases a vehicle from the dealer in a fraudulent manner. For example, maybe they were using a stolen ID or, something like that. So also just keep that in mind. False pretense is something you can certainly talk to your insurance agent about as well. Let's go ahead and delve into our dealer records. And obviously you're aware of this by now because you've had a dealer's license, but you must maintain a very extensive paper trail when you hold a Georgia used motor vehicle dealer's license. If you don't have this yet, I'm sure you do, but the most important piece of office equipment that every dealer has to have is going to be a copy machine or scanner. If you got some document relating to the operation of your dealership, you never want to throw that document away. You want to make sure and keep a copy of it. All books and records must be stored at the dealership location and available for inspection. So always remember, just by having a dealer's license, you are giving the state the right to come in and take a look at your records. Our records must always be available for inspection. You're going to create and store copies of every document related to the purchase and sale of every vehicle. If you ever think about throwing that doc away, don't do it. Make a copy of it. Georgia dealers are required to keep at minimum the following records for all vehicles bought, sold, or exchanged. You're going to have the name and address of the person from who the vehicle was purchased from, including driver's license or social security number of that person. You're going to have the date of the purchase, the name and address of the person to whom the vehicle was sold or otherwise disposed. Always make sure you got the VIN number, the date of the sale, every temporary permit issued. We're going to cover temporary permits here in a little bit. Every title and registration application that's accepted for processing, and any other information that could be required by the state or the Department of Revenue. Every record is required to be maintained and shall be retained for a period of 3 years. I want to repeat that. Remember, we have to keep all records a minimum of 3 years. Odometer disclosure forms and most federal forms are required to be kept for at least 5 years under federal law. So keep that in mind. Federal forms and odometer disclosure forms are required to be kept for 5 years. Georgia dealers are also required at minimum to maintain the following documents at your license location. Your original Georgia motor vehicle dealer's license is part of your records, and remember, it must be displayed prominently. So your dealer's license is a record, and it's got to be displayed prominently. You've also got to have any local licenses required maybe by a county or municipality where your dealership may be located. And just as I said a moment ago, I want to talk about records inspections. Georgia dealers must keep their vehicle inventory, books, accounts, and records at the established place of business at all times. These records must be open for inspection by the Secretary of State, the State Board of Registration, or the Used Motor Vehicle Dealers Board, or a representative of the Department of Revenue. All records shall be available for reasonable inspection at all times. So, if for some reason you haven't had a records inspection, I predict, eventually you will. Just, be confident. You got all your records. Don't ever, stand in the corner and act like a nervous Nelly or something like that. Let that representative know from the state, here's your records, and let them know if they can help you or whatever. And, there could be a chance they might even come in to just tell you that you're doing paperwork wrong. So, just treat them with respect and courtesy, and they'll pay that same respect and courtesy back. And just remember, by having a dealer's license, we are required to open our records to state employees during an official records inspection. Let's talk about odometer disclosure. Federal and Georgia law, and I want to remind you, obviously, federal law comes out of Washington. Georgia law comes basically out of Atlanta, or sometimes it comes out of Macon. Federal and Georgia law requires you to state the mileage of any vehicle at the time of the sale of the vehicle. I want to repeat that. Federal and Georgia law requires you state the mileage of any vehicle sold at the time of the sale of the vehicle. Federal and state law require the transfer of a motor vehicle attest to the accuracy of the odometer mileage reading at the time of the vehicle's sale, transfer, or assignment. Dealers must accurately disclose vehicle's odometer reading at the time of the sale on a secure transfer document, which could be the title, a dealer reassignment, or possibly a secure power of attorney. And here you see an odometer disclosure statement, form GA25, and I'll show you here in just a little while how you can download all these forms. We try and keep all these forms on the website, georgiadealer.com, but here in just a little bit, I'll show you how to download these forms. But there's your odometer disclosure statement, GA25. And every once in a while, you might purchase a vehicle to resell and has an incorrect odometer, which is known as a discrepancy. And in that case, you would complete odometer discrepancy form T107 that you see right here. This is odometer discrepancy form T107. So make sure you fill this out. If there are any, if you're buying a vehicle that you are aware has an incorrect odometer, this is a form that you have to use under state and federal law. So, and as a quick reminder, once again, I want you to be aware that you can download the forms that we discuss in your dealer training course at georgiadealer.com. Once again, that is georgiadealer.com. Then you're just going to scroll down to the very bottom and click on the Georgia dealer forms. So I hope that's going to be helpful for you. Okay. Odometer disclosure exemptions. Let's talk about this. The following vehicles would be exempt under the Odometer Disclosure Act, under the Federal Truth in Mileage Act. Okay, so gross weight vehicles that weigh more than 16,000 pounds, non-self-propelled vehicles such as a trailer, vehicles that are 10 years old or older, newly transferred from dealer to dealer, okay, or prior to the retail purchase. So if you're selling a vehicle to another dealer, that's going to be exempt until it goes actually to the retail customer. Let's talk about odometer fraud. I mean, I know we're not going to be doing this, but we need to be aware that odometer fraud is actually still going on, and it has become more high-tech in nature. Resetting, disconnecting, or altering a vehicle's odometer to conceal the true mileage is what we call odometer tampering, or sometimes we call it odometer fraud. It's illegal for anyone to engage in odometer fraud or sell a vehicle knowing the odometer has been altered without informing the purchaser. Tampering or knowingly misrepresenting an odometer mileage reading is also illegal under federal law, which classifies the crime as a felony and carries penalties of up to 3 years in prison and $10,000 fine per violation. That would be per vehicle. Each motor vehicle or device involved counts as a separate violation. In addition, if you're a victim of odometer fraud, you have the right to file a civil suit for damages in either state or federal court for up to 3 times the actual damages, or $1,500, which is ever great, plus reasonable attorney's fees and court costs. And I want you to be aware the National Highway Traffic Safety Administration estimates show that more than 450,000 vehicles are sold each year with false odometer readings. Odometer fraud costs American car buyers more than $1 billion annually. And as a dealer, it's important for you to know how to spot odometer fraud, how to protect against it, and who to contact if you think you are a victim of this illegal behavior. The National Motor Vehicle Highway Safety Administration has oversight over what's called the Office of Odometer Fraud Investigations, and each office is staffed with criminal investigators and administrative support. The office is tasked with reducing the cost of vehicle ownership by deterring odometer fraud and maintaining federal law and requirements. So how do you protect yourself against Odometer fraud. Well, it can be very difficult, but not impossible to detect whether a vehicle that you're getting ready to purchase has had its odometer altered. So this is something we certainly need to be aware of. So here's a couple of tips that will hopefully help you when you are buying that vehicle to resell, or maybe you're taking a trade-in. Ask to see the title and compare the mileage on it with the vehicle's odometer. And make sure to examine that title closely. If the mileage notation seems obscured or it's been altered, that's something we certainly want to be aware of. Compare the mileage on the odometer with the mileage indicated on the vehicle maintenance records. So, you can look for those oil change stickers up in the window, or a maintenance sticker, maybe on a door frame or possibly in the glove box, to see what the last recorded mileage was. Say, for example, maybe on an oil change. Check that the numbers on the odometer gauge are aligned correctly. If it's an older odometer, they're crooked, or maybe they jiggle when you bang on the dash, I would definitely be walking away from that purchase. Examine the tires. If the odometer shows, 20,000 or less miles, it should probably have the original tires that came with it. Look for wear and tear on the vehicle, on the gas, brake, clutch pedals, something seems inconsistent or appropriate for the number of miles displayed on the odometer. That's obviously going to be a red flag. Request a vehicle history report, which I'll show you how to do here in a little bit. That's going to show you the last recorded mileage on that vehicle history report, and I'll show you how to do that here in just a little bit. But, say, for example, that vehicle history report shows the last recorded mileage was 25,000 miles, and all of a sudden you look at the odometer and it says 10,000. Well, there's a huge discrepancy there, and that's certainly a vehicle I would recommend not purchasing. Digital odometers that have been tampered with are even harder to detect than a traditional mechanical odometers, since they have no visible moving parts. And, vehicle condition, a vehicle's condition and detailed history report are really some of the best clues to determine whether some odometer, what is known as clocking, has occurred. So, if you suspect odometer fraud, you definitely want to contact local law enforcement. So, we definitely don't want to purchase a vehicle that has the odometer altered and not disclose that to any future buyers. We could actually be charged with a felony on that. So please keep that in mind. We've now completed Unit 2, and I want to remind you that you can review any of these training videos that you've completed at georgiadealer.com. Once again, that's georgiadealer.com. Just click on the video links at the very top of the page, and you'll be able to view all these videos in their entirety. Now let's go ahead and move on to Unit 3.